Hello, everyone. My name is Kim Lavin, and I'm a member of the marketing team here at Verus LLC. We're a mass tort litigation support and class action administration company, and we provide solutions for law firms managing complex, high volume caseloads. Today, we're privileged to have the opportunity to talk to Michelle Greene, who, as a member of the Lanier Law Firm, has been on the front lines of the social media addiction litigation, most recently as a member of the trial team that achieved a significant verdict in the recent trial in LA. Michelle, could you introduce yourself and give us some idea of how you came to be involved in mass torts and specifically which cases you've been a part of?
Sure. So I have been practicing for about 10 years now, and mass torts has really been central to the practice. And I came into it relatively early. I've done a lot of environmental law, pharmaceutical cases. How I got into it or developed kind of an interest in mass tort, to be honest, it was when I was younger and I watched Aaron Brockovich, and I remember saying, that's what I want to do.
That's great.
So Julia Roberts recruited me to the legal profession, and I have zero regrets. But honestly, I think what really got me involved in a lot of the pharmaceutical and the mass tort world was my grandmother was prescribed DES. It was a pill to prevent miscarriages, and it was instead, it ended up giving her daughter, my aunt, ovarian cancer at the age of 18. So my
Oh,
dad's sister
geez.
died at 18 from taking this drug that was supposed to, obviously help their family, and it really destroyed my family. So that it taught me what's at stake when corporations don't treat safety as mandatory. So I think that personal experience for me really drew me to mass tort litigation. In fact, the case was discussed in my tort law class in law school. So it was huge, reason why I got into it. So mass tort felt like a real natural fit. So whether it was like pharmaceutical companies harming, patients, or chemical manufacturers contaminating drinking water, which I've worked on, or social media platforms engineering products to addict children. These are cases where, individual lawsuits alone cannot match the scale of the harm. So mass tort litigation really is the mechanism that can do that. And so the cases that I've worked on are a lot of pharmaceutical, Camp Lejeune Justice Act claims I've worked on. I've worked on PFAS and AFFF litigation, which we, can get into. And really right now, over the last 2 years, my central focus has been social media addiction litigation.
Okay. Speaking of that, you were involved in the JCCP trial.
Yes.
What were your initial thoughts on the recent verdict? And how has that impacted how you treat the litigation going forward?
Yeah. I mean, the KGM verdict was historic. It was the first time a jury found Meta and YouTube liable for negligence and for failure to warn. And that matters, right? That's not just for the family involved, but for the entire trajectory of the cases. We spent years digging into internal documents that showed exactly, what these platforms knew about the effects of the products. So watching a jury evaluate that evidence and then hold these companies accountable, it was very, it was incredible. And I learned a lot at trial, and I think the verdict really reinforced what that while the science and data matter, obviously storytelling is what really closes the deal. And we had some outstanding experts, Dr. Anna Lemke and Dr. Baggett. They examine like the neuroscience of addiction, and juries ultimately connect with people. So, and they connect with families. And so I think that it was really powerful to see not only the rigorous science, but also the compelling human story. And I think part of what made the trial so, I mean, it was just seeing how Mark Lanier operates in a courtroom too. I mean, there's this incredible ability that he has. And I think what lawyers need to have is when there's something that's incredibly dense or scientific, scientifically involved, and there's a lot of internal documents and expert testimony, and, to try to distill it into something that's a jury can follow. So he, as hard as a case may be, he'll always say the case is very simple, right? And he did. He said it's as simple as ABC, which was addicting the brains of children. So I think that, you can kind of meet jurors where they are, and so I thought that was really, it's a complicated case, but also a fairly easy one when you look at what was really happening and what they cared about. So I thought that was very interesting at trial, for sure.
So, what would be key things that you learned as a result of the litigation that other attorneys going forward with different cases in this would be well served to learn and
Uh,
follow?
you mean for a trial, or for the litigation as a whole, or?
Well, the litigation as a whole primarily, and then like
Yeah.
what sort of areas do they need to focus on going forward?
Yeah, I think going into the trial, I think one of the biggest things we were nervous about was specific causation. And so many of these clients have family issues, have, something going on in their lives that we knew the defendants were gonna, point to. And so we didn't know how it was going to be, because every client we have, there's always going to be, mental health is, the psychopathology of mental health isn't just one thing. And so that was, I think everyone was kind of waiting on what would a jury say that this specifically caused the plaintiff's injuries. And I think an example at trial, and Mark kind of explained it this way, was like a lion doesn't, and I don't know if I've spoke about this prior, but a lion doesn't chase the fastest gazelle in the herd, right? It targets the weakest one and the one that's struggling. And so these platforms operated the same way, where their algorithm was engineered to identify the vulnerability and exploit it. So a child dealing with family instability, with trauma, with other challenges, they're not less of a victim because of those circumstances. Instead, they're more of a target. And the jury felt the same way. So it demonstrated how predatory the conduct was, but an expert report can't do what that image does to a courtroom, but I think that it really showed that, yeah, they're more vulnerable to harm. So I think that was, very interesting to see, and obviously it played out well, and the jury, agreed that it's the causation is there, and that the algorithm and how, and also addiction, right? People sometimes maybe didn't realize that there is an addiction to social media. So I think having those jurors agree that social media addiction is real was huge, and obviously, amazing for the litigation and to shine a light on what's going on here, for sure.
Interesting. How can firms better prepare families and minors in the families for sort of the depth of information that's required in discovery? How do you explain to them exactly what's going to have to be put together and presented to a jury?
For the depth of information, I think starting at the like at the intake level, having that, and so not 6 months later when you're staring down a plaintiff fact sheet deadline. Families don't anticipate how granular discovery gets, like the device history, the platform usage, going back years, the mental health records, and parents can, are resistant when they realize how much information is collected. So I think the reframe that works for us is, the defense are going to argue alternate cause, and the child struggles has nothing to do, and they're going to say the child struggles has nothing to do with the platform. So we have to kind of get the full picture, and really just, like I said, start that conversation at intake, and just let them know that it will be intensive, and not deal with it months later when you're struggling, because the plaintiff fact sheet alone is 81 pages. So you really have to start kind of getting the full picture and being honest with them at what it entails at the front end. There's no way around that.
Well, and there's an obvious level of privacy involved that you're going to have to sort of educate people that this is the kind of information that's going to have to be made public.
Right, right. Yeah, I mean, obviously, if it went to trial, and we're gearing up for trial too, and things like that. But yeah, the filing a complaint, their name is there with the harms that they've suffered, and that will be public information, and that's something that maybe they decide that they don't want out there, right? That's definitely part of it.
Exactly. What's the best way you found for collecting and organizing like the data like social media usage, history, device information, the medical records? Do you have a technique, or is there something that you use to sort of cull all that information and make it tell a cohesive story?
There's a few things that are non-negotiable. First, structured intake that covers, every record from day one. We treat collection as kind of an ongoing flow. We track what's been requested, what's received, what's outstanding. You follow up, and there's a consistent, organization across the docket. Folder structures, deficiency flags at scale. Disorganization is obviously a liability. So you want to make sure that you walk through the clients on how they should preserve everything. We immediately will send a preservation letter on what they need to do and have an open line of
Okay.
communication.
How does your firm sort of manage the growing caseloads and then maintaining quality and connection with the claimant as the size of and the scale and the scope of the number of clients you have grows?
I think infrastructure has to precede volume. You can't build a plane while flying it, I say. Um, we take a tiered approach. So we have, paralegals and case managers handling defined workflows like record collection and plaintiff fact sheet prep, with attorney oversight at key decision at points. But I think communication cadence is everything. And we have a team, who medical record ordering, medical record review, helping with plaintiff fact sheets, really having people at every stage, and so nothing kind of gets lost, and clients who don't hear from you will disengage or become quote unquote high maintenance. So regular touch points, keeping families connected even during these long stretches is also important.
How do you find the best way to do that, to sort of maintain that client communication?
It's we have you just need enough people. You need to make sure you have people knowing, when you're ordering medical records, what's missing. Okay, the medical records here don't have what they said in their intake. We're constantly honestly talking to the clients because we're so on top of how, what we need for the litigation. So a lot of times it just comes organically with the work that it takes to uh, you know build up these cases. And, usually, we have a number of staff that will be in constant communication, and I'm in constant communication, but I think it takes work and it takes time and it takes dedicated people, doing this day in and day out.
And sort of growing that trust element between you and the client.
Definitely, definitely. Absolutely. It's,
Yeah.
we're asking them these delicate, uncomfortable situations. It brings up hard things. So, you want to make sure they're comfortable. And, comes a point where sometimes you have to tell them resources for seeking therapy. You also have to understand you're not their therapist or their lawyer. So there is part of that you need to balance, also being there and being supportive, but also giving them resources for help too. So it's a delicate balance. And I tell my team, and my team knows that it will open up wounds for people, and that's something that we have to deal with, and it's just how the case is. And because we're dealing with people that have had horrible mental issues every single day because of these platforms, it's unfortunate, but I think everyone is prepared and understands and is on the same page with what these clients need, for sure.
Right. To what degree do you foresee using AI as part of managing all of that data? And then what, if any, are the ethics considerations that might be involved in that?
So for AI, it's I think it's I think you at this point, if you don't use AI, you're going to be falling behind. Unfortunately, I think it's becoming increasingly an important tool in the workplace. And I think particularly in mass tort litigation, where the scale of documents and data is just so enormous, um, that, when you're managing thousands of records, AI can help identify patterns. It can help summarize documents. It can organize information. It can review medical records to an extent, help analyze deposition transcripts. I mean, that helped us for deposition transcripts to, really quickly as needed at trial. If used properly, it allows attorneys to spend less time on the repetitive, administrative work and more time on strategy and advocacy and, serving clients. That said, I want to be direct that AI does not replace lawyers. It amplifies lawyers, but the judgment, the strategy, the trust a client places in you, those all require a human being, you know.
And what are the ethical concerns that you would have to really focus on when you're dealing with AI?
Yeah, that's a good question. I think the ethical concerns, I think confidentiality, accuracy, and supervision to an extent. Attorneys must understand where the client data is going. So before using any AI platform, you need to know whether it adequately protects confidential information. Like that is not a minor consideration. Also,
Right.
AI, as we know, it can be wrong. It can hallucinate cases, and it has, and it's fluently wrong. I mean, the other day, I was trying to see if I can use a medical record with a client, and it was at some point the client was prescribed cough syrup, and it came up as a prescription for cocaine. I mean, it can,
Oh,
yeah. So, and then this happens, and it will not. So it's not perfect, and it can generate incorrect and almost and damaging information, and it can misstate facts in ways that will look completely, authoritative. So in litigation, that kind of mistake has serious consequences, and I've seen it, time and time again. So everything generated by AI must be reviewed by a lawyer who understands the underlying facts and the law, and just having eyes on it to make sure there's no mistakes. When we've seen a lot like that, and so I like AI tools, they're a risk, but so, and I've seen courts require disclosure of client communications with AI chatbots. I also want to be very clear that it's very important that clients know that courts are ruling that their chat GPT conversations may not be privileged. It may be discoverable. And we've seen that time and time again. So, firms need to warn clients about that in intake communications and follow-up and retainer agreements, that it belongs on your preservation protocol, right? Alongside, instructions not to delete things. It's something that is discoverable for clients too, that we need to keep in mind.
okay. How important do you think it is for that sort of early claimant education in keeping plaintiffs engaged throughout the process and sort of helping them understand what that's going to be involved? What's the best way to go about doing that?
I think it's foundational. I think it's, the clients who stay engaged and responsive throughout the litigation are almost always the clients who understand, the process from the beginning, and they know the timeline, and they know the records that will be needed, and they know that this litigation can be emotionally difficult, and delays are part of the process, and it's not a sign that something went wrong. So we have those conversations early in plain language. We reinforce those expectations throughout the life of the case. When clients know what to expect, and when they know, what to look for and what to expect, I think the attorney-client relationship is stronger, and the case is stronger because of it.
Exactly. You've also been involved in some other litigations, but primarily, how do you think the other addiction related litigations, like Roblox and the gaming litigation, might be similar to or different from the social media addiction?
There are common threads. I think for Roblox, for gaming, I think at their core, these cases involve allegations that companies deliberately engineered products to maximize engagement, and they all possessed internal documents or internal knowledge, sorry, about the risks of those design choices. And they failed to warn users and families. And I think the legal theories often overlap, like product liability, negligence, failure to warn. I think the difference specifically comes down to the injuries and also the available evidence. Like social media addiction has really benefited from a rapidly growing body of research linking excessive use to anxiety, depression, and other serious harms. And the research that strengthens every case we have. Where gaming litigation is really in development, and the research is still evolving. And cases involving Roblox it also introduces additional issues about like microtransactions and monetization strategies, and I believe financial harms that just don't appear in social media.
Okay.
It's a developing space worth watching, but there is some differences.
Are there differences between how you would handle cases with minors versus how you would handle cases with adults? Are there different considerations? Are some things similar as you approach the case?
I think an issue that often gets overlooked is the minor to adult transition. So there's a lot of for cases that really have a lot of minor involvement. I think um, initially parents may have signed contracts and authorizations on a child's behalf, and once the client turns 18, firms need to make sure that engagement agreements and authorizations and every other necessary document is re-executed by the now adult. And it sounds like an administrative detail, but courts will take that seriously. And if it's not handled properly, um, you will feel it later. And I think for minors, parent involvement is especially important. Parents often carry, critical information about behavioral changes, about treatment history, school performance, the day-to-day reality of living, with a child that was harmed. So I think the more they understand the process up front, the better equipped it will be when discovery begins, and the less likely that they, are disengaged at a critical moment. But I also think something, we've seen that once the client turns 18, we need to make sure that they want to continue this litigation, of course, as well. So there's,
Okay.
that too.
Will the discovery demands be similar in terms of the document required and the medical records required, or is there sort of a real differentiation between those kinds of litigations and the social media?
No, I don't know exactly. It is similar. I believe there are some, nuances with Roblox, but so I don't know. I don't want to say, it's all the same because they are different litigations, but I imagine that, they are very similar in the workup, and it's, preserving documentation and making sure you get the medical records and making sure that there's a diagnosis and there's no mismatch between what's on the intake versus what's in the medical records. So I think in that
Okay.
way they're similar.
Now, you were also involved in some other litigations. Can you talk a little bit about those and how either your experience in those informed how you approach social media, or are each one of them very distinct and different in how, in the different requirements and the different expectations?
So I worked on PFAS and AFFF litigation
Right.
for a long time. Um, Both involve large numbers of plaintiffs, extensive scientific evidence, complex causation arguments, and I think allegations that the defendants didn't disclose what they should have. And I think for PFAS and for social media, both are there. And in both settings, there's a significant part of the job that's like translating this complicated science into something a jury can follow if you're looking at trial. But the differences are primarily in the exposure pathways and injury profile, uh, similar to social media. So in PFAS and AFFF cases, you're often dealing with exposures tied to specific locations. So military bases, manufacturing facilities, contaminated water systems, and the injuries may involve cancers, obviously. But defendants run the same playbook of the cancer came from somewhere else, or genetics, or lifestyle, other environmental factors. Causation is fiercely contested, and you need strong general and specific causation, just like social media. They're no different in that respect. And in social media, they point to dysfunction or pre-existing mental health or trauma or academic pressure, or anything to redirect blame. So the fact that, I think that in both cases, causation is the battlefield, and the answer in both areas is the same: is rigorous science, credible experts, a clear narrative that shows exactly how the defendant's conduct made, a real difference in someone's life. And I think the central question never changes: is like, what did the company know? When did they know it? What did they do with that information, or fail to do with that information?
Is there a difference in sort of the sensitivity with which you have to approach a PFAS or an AFFF case as opposed to a social media litigation that results in mental harm or manifests itself in different ways? That the injuries are a little different.
Yeah, I mean, I think that in social media, you're dealing with mental health harms versus, different cancers. And I think that um, is harder. It's just a different type of harm, and you're dealing with minors. And so, I think you have to be a little bit more delicate in some situations. You need to be, like I said, sometimes you're kind of playing this therapy role in situations with young, you're dealing with minors and their parents and their family. So it's really kind of, you're dealing with the whole family. So it's more intensive when you're dealing with something like mental health versus cancers. And they're both horrible, but I think it's a little bit heavier of a process, and more of a process when you're dealing with minors, just because you're dealing with the families and you're dealing with mental health harms that also make it harder for them to maybe meet some deadlines. You need, you're dealing with people who are depressed or who are anxious. And sometimes that means that it's harder for them to complete what you need them to complete, like a plaintiff fact sheet, because of just the different harms involved.
Are there different points, flashpoints in the course of a litigation that it's more or less helpful to get sort of case management assistance, or do you have any advice with regard to at what point does it get more so complex that you need to look outside for additional assistance in managing these caseloads?
It's a good question. I think, the claimant engagement and settlement readiness, they're connected, on engagement, vendors who can conduct structured plaintiff fact sheet interviews or help collect records or, keep clients connected over a multi-year litigation provides real leverage, I think, for most firms that maybe they can't replicate internally. And, we've worked with vendors who have helped bring that in infrastructure and, on settlement readiness, that the need is clean, complete claimant data that lets you kind of evaluate inventory with confidence. So firms that haven't maintained data discipline, and they will scramble when settlement comes. So trying to figure out,
Okay.
what they actually have and what's defensible. That's the worst time to find out that your records are incomplete.
Okay.
Yeah.
If you can pull out your crystal ball, where do you envision the social media litigation going from this point? You've got this great verdict. Where do you think it heads now?
I think that, we have, shown that people are willing to have these social media companies liable. They're willing to say that, and on a personal level, one of the most significant moments was seeing Mark Zuckerberg, on the stand and being in the room and watching this, Zuckerberg on the stand, knowing that, he's one of the most, richest men in the world, most powerful men. I mean, to have him be there and to have a jury say, I don't believe you. I mean, I think it's pretty significant. And I think the PR battle is important. I think we're winning that, and we're showing people that this is a real problem. And I think it brought to light the algorithm and the harms that come from it. And I think it will for it now, there's congressional testimony, and it's really becoming something that people are tuning into, which I think puts pressure on these defendants to come to some type of agreement or settlement down the line. I think it only helps just to when we're exposing them and showing what the harms, can be and what they've been doing, and the hot docs or the internal documents coming to life. I think it's only putting pressure on these companies to just make a change and make their product safer.
And that was my next question. Having seen all that in the courtroom and seeing how the testimony was received, do you envision these companies making substantial changes to the platform or how they operate to sort of make them safer or make them better products for the general public?
The evidence in these cases tells us a lot about, what they knew. The so-called hot docs, I mean, show that these companies knew that, there was harm, and that's not speculation. So I think history suggests that corporate behavior will change most durably when there are financial consequences. So I think we saw that with tobacco and opioids, and litigation creates accountability that maybe lobbying or self-regulation just simply cannot. So some companies have made some cosmetic changes, screen time tools I've seen and age restrictions I've seen, but the core algorithmic design that hooks users remains largely intact. But I think the KGM, the verdict really did send a powerful message in that, when juries hear this evidence, they understand what happened to these kids. And when verdicts become large enough and frequent enough, right, I think that calculus for these companies will change. And the goal isn't like just compensation for clients. It's a structural change that I do believe this litigation is one of the most powerful levers on how to get there.
Yeah, as anybody who has teenagers knows, they are incredibly adept at working around sort
Right.
of the restrictions that are placed. So they have to make a real dedicated effort to do that because any clever
Exactly.
teenager will figure it out.
Exactly. Yeah, absolutely. And we've seen that
Yeah.
time and time again. And we've, said as such in the trial.
And on a similar note, where do you see the PFAS and the AFFF litigation headed?
Yeah, I've worked with a lot of water utility companies, and I think they're again the science is catching up to the exposure, and we're seeing more and more epidemiological data links with PFAS to cancers, and on a regulatory side, the EPA's move to set enforceable MCLs or maximum contaminant levels was a significant development. I know that there's been some changes, but we've seen major settlements with 3M and DuPont, but those resolved primarily with water utility claims. And I know, individual personal injury claims are a different animal, and that docket is still, being worked out. But I do expect to see significant, activities in those cases. But what's also interesting is the expansion between, traditional defendants. So we're starting to see claims against manufacturers of products that used, PFAS, like cookware and food packaging, and so
Hmm.
not just the chemical companies themselves, but I think it's PFAS litigation is one of the most significant mass tort dockets of the next decade. The exposure is so widespread, and the population affected is enormous. It has hallmarks that I think will reshape an industry. But I think water utility is they I think people have said, we don't want to bear the burden of these costs. Operation and maintenance alone and enacting like GAC, granular activated carbon treatments, costs millions of dollars. So I think that there's more and more litigations representing water utilities because they're bearing the cost of trying to filter out this PFAS. So I think similar to social media, it's on the forefront. More PR means more pressure on these companies.
Well, that this has been a fascinating conversation, Michelle. I really appreciate it. Do you have any sort of closing comments or remarks you'd like to make before we sign out?
The only thing I'll say is mass tort litigation is ultimately about accountability. And so whether the case involves pharmaceuticals, environmental contamination, PFAS, social media addiction, I think the mission is the same as, you uncover the truth, you give families a voice, hold corporations accountable when they've chosen profits over people's safety. And I think that's what drives this work and what will keep us in the fight, as long as these cases demand it. So that's
Oh,
really
that's
all I have to say.
Thank you so much. I really appreciate you taking the time.
Of course, of course. Thank you so much. I appreciate you. Let me know if you need anything at all.